launched a project looking specifically at state responsibility for modern slavery. We identified 5 scenarios in which states are involved in modern slavery, and we prepared a policy paper with recommendations that we presented at United Nations headquarters in New York. So our third scenario of state involvement in modern slavery is where diplomats traffic domestic workers into a jurisdiction, capital cities around the world, and then exploit them in their residence in a form of domestic servitude, forced labour and human trafficking. We were contacted following our launch of our research by a lawyer who had a test case of a woman who had been brought to the UK and had been exploited by a diplomat right here in London.
So initially we took the claim to the Employment Tribunal, and the diplomat had brought an argument against us to say that there was no claim that he would have to answer as there was diplomatic immunity. Diplomats are generally protected from all criminal liability and most civil liability for their activities in state countries that they are visiting. However, there is a small exception for a commercial activity that the diplomat would partake in, and our argument was that the activity of receiving a domestic servant and continuing to exploit her amounted to a continuation of this commercial activity. And we're really pleased that the Supreme Court here in the UK has recognised the nature of this kind of activity and has provided this legal remedy for victims who, as we know, are brought from all areas of the world here to be exploited in diplomatic households. Having the resources of the King's College Law School and all of their students to provide that international research meant that we were able to balance the scales in order for us to give, a fighting chance to take this case all the way.
It feels very surreal, to be honest. It's weird to think about all the hours we spent in the library, researching law, and then to see it have a tangible effect and make a difference in practice. So it's hard to sort of fully appreciate, but it's also very empowering to know that as students we get opportunities whereby we can use our skills, use our training, and have an effect on society.
Ultimately, international law is a very strong tool for change, but for that change to be really effective, a lot of change within international law itself still needs to occur. And I would like to be myself a part of this process in the future, as I have been able to be on a very small scale whilst working with Rosanna and Philippa on this project.
In this journey since the research started, one of the pillars of the work we've done has been the work with our students who have engaged enormously with this important project. They've developed research in a very rigorous way, engaging with the cases, engaging with the legal arguments, and their motivation has been remarkable. We're really proud of the work that they've contributed to this project.
My involvement in the project was as a student researcher. We researched international law precedent, anything we could find, any angle we could find, in order to support the Supreme Court submissions in the Wong and Bashfar case.
Witnessing firsthand how a group of exceptional lawyers meticulously drafted an argument and, in the end, succeeded in convincing the UK Supreme Court to set a new precedent, strongly influenced my notion of a lawyer's work and its real-life impact.